If you own a gun in America, the legal ground just shifted under your feet this month. A federal appeals court handed down a decision that tears apart decades of gun control framework, and 10 massive changes are already in effect right now. Law number 10 is so shocking that what used to be a 10-year federal prison sentence is now your constitutional right. Hit that subscribe button and turn on notifications immediately, because what I'm about to show you could be the difference between staying legal and facing serious criminal charges. A massive shift just happened in how courts treat your gun rights, and if you miss this, you're going to be caught off guard when everything starts changing around you. Federal courts are now treating your Second Amendment the same way they treat freedom of speech and freedom of religion, which puts it at the top tier of constitutional protection. This matters more than you think, because it completely reverses who has to prove what in court. Every time any level of government wants to pass a restriction on firearms, they now face what lawyers call strict scrutiny, and this is the toughest standard that exists in American constitutional law. Now they have to prove 3 separate things, and all 3 have to be rock solid. They need to show a compelling governmental interest, which means the problem has to be urgent and severe, not just something that sounds like a good idea. They have to prove the restriction they're proposing actually solves that problem effectively. Most importantly, they have to prove there's no other possible solution that would restrict your rights any less than what they're proposing. Now, the government has to justify why they should be allowed to stop you, and the requirements are so demanding that most restrictions simply cannot meet them. Constitutional scholars who've studied this ruling say between 60 and 70% of current gun regulations across the country will fail this test. But this new protection only works if the people enforcing these laws actually face consequences when they violate your rights. Law enforcement officers who violate your Second Amendment rights now face direct personal liability, and this is already changing how police interact with armed citizens across the country. There used to be a legal doctrine called qualified immunity that worked like a bulletproof shield for officers who violated constitutional rights. That shield has been completely stripped away for Second Amendment violations. Any law enforcement officer at any level, whether it's a city patrol officer, a county sheriff's deputy, a state police trooper, an ATF special agent, or an FBI investigator, can now be held personally responsible when they violate your gun rights. In Harris County, Texas, a judge ordered 3 officers to personally pay $2.4 million after they arrested someone for open carrying when Texas law explicitly allows it. A Broward County, Florida officer is facing federal civil charges and lost a pension worth approximately $890,000 over his career after confiscating legally owned guns during a traffic stop when he had no legal authority to do so. Out in Maricopa County, Arizona, a sheriff's deputy got hit with a personal fine of $156,000 and a permanent ban from working in any law enforcement position anywhere in America after he held onto someone's concealed carry firearm for 6 hours without any legal justification. Officers are being warned in the most direct language possible that violating gun rights will destroy their career and their financial life. What would you do if you knew the officer who violated your rights would personally pay the price, instead of hiding behind their badge? But officers aren't just violating rights during arrests. Taking someone's firearms without following complete criminal procedures has been ruled unconstitutional, and people who lost guns under these programs are getting them back right now. Red flag orders, civil forfeiture involving firearms, and administrative confiscations have all been struck down under the new constitutional standard. The way these programs worked was genuinely disturbing when you look at the details. An ex-spouse going through a bitter divorce, a neighbor who didn't like you, someone you got into an argument with at work could file a complaint. Police would take that complaint to a judge and get what's called an emergency protective order or a red flag order. Then they'd arrive at your home, sometimes without you even knowing a complaint had been filed against you. Every firearm you owned would be confiscated on the spot. Your guns were simply taken, and if you wanted them back, you had to hire an attorney and fight through the court system for months or even years with no guarantee of success. The recent ruling makes the requirements absolutely clear. Firearms cannot be seized without placing someone under arrest. The entire process requires full due process protections, including the right to confront accusers, question witnesses under oath, and present defensive evidence. Across 21 states that had red flag laws, police confiscated firearms in roughly 15,000 cases last year. In more than 2/3 of those cases, no criminal charges ever got filed. Some states took an average of 14 months to return firearms, and gun owners spent between $8,000 and $12,000 on average in legal fees fighting to get their own property back. Police would seize firearms claiming they might have some connection to criminal activity somewhere, even when the owner wasn't charged with anything or suspected of anything. Anyone who had firearms taken through red flag orders or civil forfeiture within the last 5 years now has clear constitutional grounds to demand immediate return. Time is limited, though, because most states have created a 90-day filing window, so anyone in this situation needs to act immediately. But confiscation wasn't the government's only privacy violation. The federal government has 90 days to permanently destroy every digitized gun owner record they've been collecting. And this represents one of the most significant privacy victories for firearm owners in American history. The ATF spent years building an enormous searchable database tracking who owns which guns, and the scale of what they compiled is staggering. When gun dealers closed their businesses, the ATF collected all their paper transaction records and digitized them. The system let them type in any name and instantly see every gun purchase that person made. They could search by firearm type and find everyone who purchased AR-15 rifles or any specific handgun model. Serial numbers, calibers, purchase dates, dealer locations, everything was indexed and searchable in seconds. The violation goes even deeper. 6 states were actively feeding information directly to federal databases through information sharing agreements. California, New York, Connecticut, Illinois, Maryland, and New Jersey all sent state-level purchase records to federal servers where they were indexed and made available to multiple government agencies. The court gave the ATF a hard 90-day deadline to provide certified proof that every digital record has been permanently erased. Independent forensic computer auditors have to verify the information cannot be recovered through any means. The officials responsible, including the ATF director and senior leadership, could face criminal penalties, including substantial fines and imprisonment. The FBI's background check system also received orders to delete records after approving purchases. Official FBI policy always claimed they didn't retain records of approved gun sales, but internal audits proved they kept that data for an average of 7 years. What would you do if you discovered the government had been secretly tracking every firearm you ever purchased? The ruling makes it clear that private information belonging to law-abiding gun owners cannot be collected, stored, digitized, or shared between government agencies without a warrant based on probable cause of a specific crime. But the government wasn't just keeping static records. Federal agencies are now prohibited from conducting surveillance on lawful gun owners without obtaining warrants, and the monitoring programs that just got terminated are absolutely shocking. Government agencies spent years tracking gun owners through digital footprints in ways most Americans never suspected were happening. The NSA ran a program with an internal designation of Gunwatch that automatically flagged people based on internet searches. Searching for terms like bulk ammunition, AR-15 parts, concealed carry laws, gun show schedules, or FFL transfer procedures put you on a monitoring list. The Department of Homeland Security operated a separate program monitoring firearms purchases through the financial system. Spending over $1,000 on guns or ammunition within any 30-day window automatically flagged your name for analyst review. The ATF ran a program called Time to Crime that supposedly tracked how long guns took to go from dealer inventory to being used in crimes. They monitored private sales between individuals by watching online classifieds, Facebook marketplace posts, gun forum discussions, and even private messages between people mentioning firearms. Every one of these programs has been completely shut down following the court ruling. The decision makes it explicit that owning guns is a fundamental constitutional right, and exercising that right cannot justify government surveillance. Government cannot monitor everyone attending church just because they're exercising First Amendment religious freedom. Identical protection now extends to all Second Amendment activity. Cell phone location data related to gun store visits is protected. Credit card purchase history for firearms and ammunition is protected. Any government agency wanting access to digital information connected to guns must now obtain a warrant based on probable cause of an actual crime. Over 50,000 gun owners were being actively monitored through these programs without knowing it was happening. Early settlements are averaging around $40,000 per person, with some cases reaching $75,000 or higher, depending on monitoring extent and duration. But surveillance wasn't the only obstacle the government created. Concealed carry permits must now be issued faster, easier, and cheaper, regardless of which state you live in, with 3 mandatory requirements every state must follow. Processing must be completed within 30 days maximum from submission. Total application fees are capped at $50, including all associated costs. States must accept standardized training from any certified instructor nationwide. States like New York were taking 8 to 12 months to process single applications. And that timeline started after completing training, submitting paperwork, and paying all fees. California charged $300 or more when combining application fees, fingerprinting fees, background check fees, and processing fees. New York currently has 47,000 permit applications pending for more than 30 days. Hawaii had issued only 226 total concealed carry permits in the entire state before this ruling. They've been forced to approve over 3,000 applications in the past month alone, with another 8,000 pending applications that must be processed within the 30-day window. What would you do with a carry permit you've been waiting months or years to receive? Any permit application pending more than 30 days is automatically approved by federal law right now. Send a certified letter to your permit issuing agency demanding immediate issuance, and specifically cite the federal court ruling. Anyone previously denied for failing to show proper cause or good reason can submit new applications, and the old denial cannot be used against them. His is creating the largest expansion of concealed carry rights in United States history. That represents millions of newly armed citizens legally exercising constitutional rights, but permits me nothing without ammunition access. Ammunition purchases are now treated identically to any other legal product, with states prohibited from imposing special restrictions that don't apply to other consumer goods. California required background checks for every ammunition purchase. New York banned all online ammunition sales and prohibited shipping ammunition into the state. Connecticut imposed limits on ammunition quantity that could be purchased at once. Illinois required ammunition purchaser identification cards that took months to obtain and cost $10 annually to maintain. The court stated what should have been obvious from the start. Restricting ammunition while claiming to protect gun rights is equivalent to protecting free speech while banning paper and ink, so nothing can be written. The Second Amendment protects the right to keep and bear arms, and the term arms necessarily includes ammunition by fundamental logic. California alone conducted over 4 million ammunition background checks last year. Many denials resulted from clerical errors like mismatched middle initials, outdated addresses still in systems, or slightly different name spellings. All those restrictions are now unconstitutional. Ammunition retailers can sell over the counter without special paperwork, background checks, or registration requirements. Ammunition can be purchased from any source offering the best price without worrying about state borders. Stocking up during sales carries no legal concerns. Online retailers report sales increased 340% in states that previously banned shipping. An estimated 2,800 retail stores that completely stopped selling ammunition due to regulatory burdens and liability concerns are bringing it back into inventory. But individual buyers weren't the only ones facing government obstacles. Licensed firearms dealers finally received the same legal protections as other legitimate businesses, ending the ATF's ability to shut down gun stores over minor paperwork mistakes. The ATF used extremely aggressive inspection tactics and zero-tolerance enforcement to close gun shops over clerical errors that would never result in closure for any other business. Recording a buyer's middle initial incorrectly, writing a date in the wrong format, using abbreviations instead of full words, having smudged ink on a single line, these were treated as willful violations, justifying license revocation. The ATF wasn't looking for actual criminal violations. The new legal standard provides clear protection. The ATF cannot revoke federal firearms licenses unless there's an actual criminal violation with intentional lawbreaking and criminal intent. Minor paperwork errors require written warnings. Corrections can be required, but licenses cannot be revoked. Anyone currently applying for a federal firearms license must have their application processed within 60 days maximum. 60 days is the absolute maximum, or licenses are automatically granted. Home-based firearms dealers facing harassment from local city and county zoning boards now have federal protection. What would you do if the ATF shut down your business over a paperwork error? The ATF revoked 122 federal firearms licenses in the past year alone for what they classified as willful violations. But examining actual cases shows most were really paperwork errors and formatting mistakes. Applications for new federal firearms licenses increased 89% in just the past 2 months because people are no longer afraid of arbitrary enforcement destroying their businesses over nothing. But business protection isn't the only area where property rights matter. Federal agents are now prohibited from entering property for firearm inspections without warrants, ending surprise compliance checks completely. ATF agents had a practice of appearing unannounced at gun collectors' homes and homes of federal firearms license holders and demanding to inspect collections or examine record books. The court ruling makes the law absolutely clear. Federal agents need warrants with specific criminal allegations before searching property. This protection applies to everyone. Private collectors owning guns as hobbies, commercial shooting ranges, retail gun stores, homes, and business properties have identical Fourth Amendment protections, whether guns are involved or not. The ATF conducted over 2,400 warrantless home inspections in the past 3 years. Average settlement amounts being paid are running around $75,000 per case, with some exceeding $100,000 depending on violation severity and specific circumstances. Federal agents appearing at your door without advance notice require a very clear, calm, and firm response. State, show me a warrant listing specific criminal allegations, or you cannot search my property. But absolute firmness about asserting rights is essential. But property rights provide limited help without travel freedom. Traveling across state lines with firearms no longer carries arrest risk in restrictive states, affecting more gun owners daily than any other change. This is what previously carried 10-year mandatory minimum federal prison sentences that's now completely legal and constitutionally protected. Gun owners were terrified for years of driving through states like New York, New Jersey, Maryland, Massachusetts, Connecticut, California, or Illinois, even just passing through. A man traveling from Pennsylvania to a Vermont shooting competition got stopped in New Jersey for minor speeding. Police searched his vehicle and found competition firearms locked in hard cases in his trunk, completely unloaded, ammunition in separate containers. New Jersey arrested him for unlawful firearm possession. He spent over $63,000 in legal fees fighting the case for 3 years before charges were finally dropped. A woman driving from Texas to Maine for holiday family visits got pulled over for a broken taillight in Maryland. She spent 18 months fighting charges and nearly lost her job from missing so much work for court appearances. The new federal protection provides absolute clarity and complete coverage. If firearms are legal in the state where trips start and legal in states where trips end, federal law provides protection during the entire journey through every state in between. Stops for gas are allowed. Stops for restaurant meals are allowed. As long as firearms remain properly secured in vehicles and continuous transit from point A to point B continues, arrests and prosecutions cannot happen. New Jersey alone arrested over 800 people in the past 5 years for possessing firearms while traveling through the state. Thousands more cases across other restrictive states are being dropped. Police stops while traveling with firearms require a simple, direct, and completely protective phrase. State, I'm traveling under federal interstate protection with a lawfully owned firearm secured for transport. This changes everything for gun owners, traveling for work, vacations, hunting trips, shooting competitions, or family visits in other states. The fear of accidentally committing felonies just by driving through the wrong state with legally owned guns is completely finished. These 10 laws are active right now, and they only protect you if you know they exist and actually use them. If you found this information valuable, hit that subscribe button and turn on notifications so you don't miss critical updates that could save you from arrest or help you recover confiscated property. Share this video with every gun owner you know, because this information could prevent someone from facing felony charges or losing thousands in legal fees. Drop a comment below telling me which law shocked you the most and whether any of these changes have already affected you personally.